What appears at first glance to be a dispute over water, over rivers and lakes, and the politics of scarcity, is in truth something far more consequential. When a president of the United States speaks casually of abandoning treaties that have governed shared natural resources for more than a century, when he characterizes the largest freshwater system on Earth as though it were a domestic fixture to be turned on at will, the question before us is not merely one of environmental policy or international negotiation. It is a constitutional question. It is a question about the rule of law, about the separation of powers, and about whether enduring legal commitments can be treated as disposable instruments of momentary political will. You have heard the remarks. A public suggestion that Canada's freshwater is akin to a faucet that can be opened and directed southward in a matter of days. Reports that senior officials described long-standing Great Lakes agreements as easy to abandon. Assertions that the network of treaties governing the Great Lakes and the Columbia River could be torn up or cast aside if they stood in the way of executive objectives. These are not ordinary policy debates about allocation or conservation. They implicate solemn international compacts and federal statutes enacted by Congress and signed by a president. The Great Lakes are not an abstraction. They comprise roughly 1/5 of the world's surface fresh water. They provide drinking water to tens of millions of Americans and Canadians. They anchor an economic region of immense scale. The Columbia River, originating in British Columbia, sustains hydroelectric infrastructure, irrigation systems, and commercial navigation across the Pacific Northwest. These waters are governed not by whim, but by a dense framework of law. Bilateral treaties, such as the Boundary Waters Treaty of 1909, interstate compacts, such as the Great Lakes Compact, and federal statutes that codify and enforce those arrangements. Under our Constitution, treaties are not rhetorical devices. Article 2 provides that the President may make treaties, but only with the advice and consent of the Senate. Once ratified, and once implemented through federal law where necessary, such agreements become part of the supreme law of the land under Article 6. They bind states and federal officers alike. Interstate compacts, approved by Congress, carry similar weight. They are not mere understandings between governors. They are congressionally sanctioned legal regimes that define rights and obligations across state lines. When a president suggests that such agreements are easy to abandon, we must ask a basic constitutional question. By what authority? The Constitution vests the executive with significant foreign affairs powers, but it does not grant a general license to disregard statutory law. If Congress has enacted a compact into federal law, as it did with the Great Lakes Compact in 2008, The President's duty under Article 2 is to take care that the laws be faithfully executed. That duty is not conditional upon policy preference. It is structural. It is foundational. History offers perspective. The Boundary Waters Treaty has endured for more than a century. It survived 2 world wars, the Cold War, and periods of profound political disagreement between neighboring governments. It endured precisely because it was treated as law, not as leverage. Likewise, interstate compacts have long served as instruments of cooperative federalism, allowing states to manage shared resources within a constitutional framework. They represent deliberate decisions to constrain unilateral action in favor of stability and predictability. The separation of powers was designed to prevent precisely the kind of concentration of authority that would allow one branch to unravel settled legal commitments without deliberation. Congress legislates. The President executes. The Senate participates in treaty making. The courts stand ready, when called upon, to interpret and enforce the law. Each branch has defined responsibilities. No branch is permitted to collapse those responsibilities into a single will. In the present controversy, the danger does not lie in strong rhetoric alone. Political speech, even imprudent speech, is not itself unconstitutional. The danger arises if rhetoric signals a willingness to test the outer limits of executive authority against statutory and treaty-based constraints. If long-standing agreements governing shared water resources are treated as bargaining chips rather than binding law, the stability that undergirds both domestic federalism and international cooperation begins to erode. Water flows according to gravity. Law endures according to fidelity. The framers understood that natural forces are indifferent to politics. So too, in a different sense, is the constitutional structure. It does not bend simply because a particular office holder wishes it to. The question before you is whether we will insist that it remain so. The Constitution does not contemplate a presidency unmoored from enacted law, even in matters touching foreign relations. It contemplates energy in the executive, to be sure, but energy disciplined by text, by statute, and by institutional restraint. When the executive branch engages another sovereign concerning shared waterways, it operates within a lattice of obligations already defined by treaty and by congressional enactment. The Great Lakes Agreements and the Columbia River Treaty are not informal arrangements that can be dissolved in a moment of frustration. They are instruments negotiated over years, ratified through constitutional processes, and integrated into domestic law. You should understand what that means in practical terms. The Great Lakes Compact, approved by Congress and signed into law, prohibits large-scale diversions of water outside the basin, except under carefully circumscribed conditions. That prohibition binds the 8 Great Lakes states as a matter of federal law. It also binds the executive branch. A president cannot, by directive or declaration, authorize what Congress has forbidden. To do so would not be an act of policy innovation. It would be an assertion that the Take Care Clause yields to preference. Similarly, bilateral treaties governing boundary waters establish joint institutions and procedures. They create expectations not only between governments, but among citizens and industries whose livelihoods depend upon predictable management of shared resources. When one party signals that such treaties are disposable, the signal reverberates far beyond diplomatic circles. It introduces uncertainty into energy markets, agricultural planning, municipal infrastructure, and cross-border commerce. Law, especially in the domain of natural resources, exists to remove such uncertainty. Some will argue that presidents have, at times, withdrawn from treaties. That is true. The historical record reflects episodes in which the executive has terminated agreements, sometimes with congressional acquiescence, sometimes amid dispute. But those episodes have almost invariably involved explicit legal processes and often substantial interbranch consultation. They have not rested upon a theory that statutory constraints may be ignored if they prove inconvenient. Nor have they involved interstate compacts embedded in federal law, the alteration of which would require legislative action. The distinction matters. In our constitutional order, foreign policy is not an executive monopoly. It is a shared enterprise, structured by enumerated powers. Congress regulates commerce with foreign nations. It controls appropriations. It may enact implementing legislation for treaties and compacts. The Senate must consent to treaties. The President conducts negotiations and represents the nation abroad. None of these authorities exist in isolation. When rhetoric about tearing up water agreements surfaces, therefore, the institutional question is whether the other branches will assert their roles. Governors of affected states, whose citizens rely upon Great Lakes water, possess both political and legal interests in maintaining the compact. Members of Congress who voted to approve it have a duty to defend the statutes they enacted. Courts, if presented with a concrete dispute, would be obliged to determine whether executive action comports with governing law. This is how separation of powers is meant to function, not as confrontation for its own sake, but as mutual reinforcement of constitutional boundaries. There is also a federalism dimension that must not be overlooked. The Great Lakes states entered into a compact precisely because no single state could protect the resource alone. Congress consented, transforming that compact into federal law. If the executive were to disregard it, the injury would not be abstract. It would be an intrusion upon a carefully calibrated balance between national authority and state sovereignty. The Constitution permits such compacts to stabilize shared governance. It does not permit their unilateral dissolution by one branch. In moments like this, clarity is essential. The question is not whether water scarcity in parts of the United States is a serious challenge. It is. The question is not whether international negotiations may evolve over time. They may, and often must. The question is whether constitutional mechanisms will be honored in that evolution. Will changes, if sought, proceed through legislation, treaty amendment, and cooperative federalism, or will they be attempted through executive assertion untethered from statutory text? The rule of law is tested not only in crises of open defiance, but in episodes of gradual normalization. If citizens come to accept that long-standing legal frameworks can be brushed aside with a statement from a podium or a phone call between officials, then the discipline of constitutional process weakens. And when that discipline weakens in one domain, it seldom remains confined there.